You just can't seem to follow the rules.
She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
You just need to just stop blaming them.
All right, everyone. Today's court hearing gets intense. Judge Simpson is dealing with a defendant who just can't seem to follow the rules. This man is back in court because he tampered with his electronic monitoring device and met up with the same woman involved in a past domestic violence case. Judge Simpson doesn't hold back. He firmly reminds the defendant that when you're out on bond or probation, messing with your monitoring device is a fast way back to jail. The defendant tries to make excuses, but the judge isn't having it. This is definitely one of those cases that grabs your attention. Let me know your thoughts on this court hearing in the comments as we watch how Judge Simpson handles the situation. Let's jump in.
Mal Carter. Thank you. Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case. However,
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know. You're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already. So.
It's a charge of interfering with electronic communication device, the 2-year felony, and then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honor's indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
I understand that the lawyer is doing his best, but let's be honest. This guy really made things worse for himself. He didn't just ignore the judge's warning. It's like he walked out of court and decided the rules didn't apply to him. He went right back to breaking the law, even after being clearly told to stay out of trouble. It's kind of like being told not to touch something and then immediately breaking it on purpose. You know that's not going to end well. And now he's standing there acting surprised, like he didn't see this coming. But hang tight, Judge Simpson is about to give him a serious reality check. And something tells me it's not going to be pleasant. If this guy thought he could talk his way out of it, he's in for a rude awakening. Judges don't forget. And I have a strong feeling he won't be walking out of that courtroom today as a free man.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. later. And I will tell the court after review of the police report, the person representing themselves to be the defendant, they have contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the defendant, because the police officer wasn't speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back, represented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on this court for probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation, revoke the probation, and sentence the defendant to serve balance at this time. And in bond in this case, we're assessing for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. Better, I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So. But I wouldn't. But
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
This is about to get interesting. Let me get this straight. This man has a restraining order that clearly says he must stay away from this woman. The last time he was in court, the message was loud and clear. No contact, no excuses, not even being near her. And now, he's been caught meeting up with her again, and somehow thinks he can talk his way out of it. I'm already bracing myself for whatever explanation he's about to give, because chances are it's going to be pretty far-fetched. At this point, the only thing left for him to claim is that he was forced into the meeting against his will. And even that probably wouldn't fly. Judge Simpson isn't one to go easy in situations like this, and I have a feeling he's about to make that crystal clear. Let me know what you think of his excuse, because this is going to be one of those moments you just have to hear to believe.
She put up on me. I was in the room playing my game, and she came in the room. And
Then you get up and leave.
tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car, and that's when I pulled off.
Well, maybe that's all going to come out, Mr.
I
Tom
understand.
Carter. Maybe that's all going to come out. I let you out the last time. Should have, of all rights, locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? I end up, you get that other case set for exam. Then what ends up happening? I get here and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is.
I
You have got all of these charges.
understand. I take
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I pose sentence on that case?
Want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. You understand it. When I get out this situation this time, I'm gonna be by myself. I just know
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
And Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Dawn Farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in-jail DV program is what I meant to say. Thank you. Defendant's remanded.
And that, folks, is exactly why it's so important to follow the law. Look, we've all made mistakes. It happens. You make a bad decision and later realize it wasn't the smartest move. But going right back out and doing the same thing again after being warned, that's not just a mistake anymore. That says a lot about who you are. In this case, the defendant made it clear he wasn't taking the court seriously. At this point, jail might be the only thing stopping him from ending up right back in front of another judge. Speaking of which, I've got to say something about Judge Simpson. He does not tolerate this kind of behavior. And honestly, it's refreshing to see. You could see the frustration on his face. It's clear he's tired of dealing with repeat offenders who keep wasting the court's time. And really, who could blame him? Judges hear excuse after excuse every day. After a while, I'm sure they can tell within seconds whether someone is being honest or just trying to dodge responsibility. In most states, violating a restraining order is a criminal offense, and depending on the circumstances, it can carry serious jail time. So when someone stands there acting like it was all just an accident, you can imagine what the judge is really thinking. And today, Judge Simpson wasn't buying any of it. Not for a second. And I respect him for holding the line. Anyway, that's going to wrap it up for this one. Let me know what you thought of this court hearing. It definitely had some wild moments. If you enjoyed this, don't forget to like and subscribe for more daily content. I really do appreciate you watching. Take care, and I'll see you in the next one.